For the court this morning is the case entitled James Fiske and Tina Fiske versus Carrie Halkiotis. Case number 23 AP-420. Representing the appellant, Carrie Halkiotis, is attorney Patrick Ancuda. Representing the appellees, James and Tina Fiske, is attorney Jeffrey M. Messina.
All right, appellant's counsel, you may begin by introducing yourself and your client and then proceed with your argument.
Thank you, Your Honor. May it please the court, I'm Patrick M. Ancuda, and a longtime associate of Parker and Ancuda PC in Springfield, Vermont. I represent the appellant, Carrie Halkiotis. The relevant facts of this case were adequately laid out, I believe, in the appellant's brief, and I won't belabor those. The principal argument is that the lower court in Windsor failed to address adequately the appellant's claim for unjust enrichment in this case. The law of unjust enrichment is well established in Vermont. A party may not enrich himself at the expense of another is the basic premise. Whether an unjust enrichment occurs or is determined may not be determined by some narrow view of the circumstances of the case, but must be based on a realistic and broad analysis of the total circumstances and the human setting involved, as stated in Legault v. Legault 142, Vermont at 531. In this case is a 10-year cumulative history of events, beginning with a lease agreement and a purchase and sale contract from March 2010 and resulting in ultimately an eviction in May 2020 of my client. There are three elements to the appellant's claim for unjust enrichment. The Fiskes received a benefit of $185,000 in deposits on the purchase and sale contract. They accepted that benefit and retained it under circumstances that were unfair to my client. The lower court,
Mr.
yeah,
Ancuda, wasn't the original purchase and sales contract had a provision in it that the deposit was refundable if certain criteria were not made, certain conditions of the contract weren't made. But didn't the
that
second purchase and sales contract have a non-refundable deposit?
it did. It did. The and one of the issues here that I'll get to in shortly is that whether that forfeiture of $185,000 was just and fair to my client, and we argue that it was not. Um, as noted in our brief, the analysis should have started with the purchase and sale contract itself. The Prove v. Royer analysis, which is 193 Vermont 12, is the case, which was presented by the appellant to the lower court in a memorandum of law post-trial, was basically ignored. Our view is that it was a contract for deed. It started out as a basic purchase and sale contract, but over time, with the accumulated deposits, when my client in possession of the property, that it ultimately became a contract for deed, and provided that the appellant would occupy the property and make payments and deposits pending the closing of the deed or conveyance of the deed at a closing.
And when did that occur, Mr. Ancuda? When did this agreement switch from a standard purchase and sale to a contract for deed?
Well, I think it always was a contract for deed. Under Prove v. Royer, it's the analysis is it's when the purchaser takes possession of the property and makes deposits, and that started right at the beginning. They extended the closing date many times throughout this and added in new deposits by agreement of the parties, and that ultimately caused the amount of the deposits to rise from the initial $85,000 to $185,000. And the deposits included more than just the deposits on the contract to be applied to the purchase price. They included the payment of the real estate commission of the sellers, because the sellers got in a fight with their real estate agent when the contract got extended the first time, and additional payment of the attorney's fees for the Fiske's attorney. That was by agreement of the parties. and as the case of Prue points out, an accumulation of this kind of deposits becomes an equitable interest in the property. And that's the way we argue it here, Your Honor, Your Honors. Furthermore, the lower court failed to consider the Fiske's actions that derailed the contract, which I think are vitally important. In late summer of 2017, in an addendum to the PNS, for the first time, the Fiskes demanded terms requiring Mr. Halkiotis to assume and pay any capital gains taxes related to and related costs related to the transaction, and that the Fiskes would probably incur at closing. The Fiskes, however, would not provide any information to my client or to me through their attorney on what those taxes or costs might be.
Right, and
It
you're
was
out of time, Mr. Ankuda.
What's that?
And so you'll have to leave it there, please. All right, counsel for the appellee, you may introduce yourself and your client and proceed.
Good morning. May it please the court, my name is Jeffrey Messina, and I'm appearing on behalf of appellees James and Tina Fiske. Your Honors, the equitable remedy of unjust enrichment does not apply here. In DJ Painting versus Barra Enterprises, this court held that where the parties have a contractual relationship, the doctrine of unjust enrichment cannot be used to circumvent the contract. Here, the parties created a contractual relationship, two in fact. The parties entered into two distinct contracts, one for the lease, one for the rental, and the other for the purchase and sale. Appellant, a sophisticated businessman and at the time Vermont licensed real estate agent, knowingly and willingly negotiated and entered into the lease and separate purchase and sale. When he could not close on the initial PNS, he had the opportunity to exercise the financing contingency within the document and chose not to do so.
Does it matter if this court considers this agreement to be a standard purchase and sale, or whether it's a contract for deed, as Mr. Ankuda argues?
We argue that it neither apply, Your Honor, and if the court will allow, I will address the contract for deed in just a moment.
Go ahead.
Appellant could have terminated the PNS or refused to continue entering into the addendum after addendum after addendum when it was clear that he could not secure financing, but he did not. Instead, when the initial lease and PNS terminated by their respective terms, because the appellant could not close, he knowingly and willingly negotiated and entered into the lease extension and each new addendum, the first, the second, the third, and the fourth. Also, implicit in the trial court's decision is that this matter is based in contract. The trial court's decision to award my client's appellee's claim for back rent sits in contract. So unjust enrichment does not apply here. However, to the extent the court considers the equitable remedy of contract for deed, which we don't think it should, appellant must lose as a matter of law because the elements for contract for deed are not met here. In short, in order to find a contract for deed giving appellant equity in the property, the court must find both a bilateral contract and that payments made reduce the purchase price as they were received. Of course, we cannot argue that this was not a bilateral contract. However, payments did not reduce the purchase price as they were received. While the court did find a contract for deed in both Kellogg and Prue, each case is distinguishable from the facts in this matter. In Prue, there was ambiguity in the parties' written agreements, and this court found that the parties intended for payments to lower the purchase price as they were received. In Kellogg, this court held that the parties understood that the buyer was to receive title immediately, secured by a note and mortgage, and payments lowered the purchase price as received. None of that is the case here. First, there's no ambiguity in these two distinct written agreements. There were two contracts, one for the purchase and one for the rental. We have credible testimony from Attorney Lewis that he specifically designed this transaction to ensure appellant did not receive equity in the property prior to close. Attorney Lewis specifically stated this was not a rent to own and there was no mortgage as to prevent appellees from having to foreclose rather than evict appellant if he didn't close, which he didn't.
Was it an accommodation, Mr. Messina, to allow the appellant to stay at the property, pay rent, and then have the option at some point to purchase if he could secure financing?
Your Honor, this went on for 7 to 8 years. This was supposed to be a 2-year transaction. My clients moved to New York. They didn't want to be landlords. The whole purpose of allowing him to be in there was that he was going through a divorce and they were trying to help him to be able to do this. And they kept entering into these agreements after the initial one or the preceding one terminated by its terms. There were no accommodations. About 8 years in, appellees were just tired of having to do this and they wanted to sell the property. So that's when they moved to evict, because the purpose of Mr. Halkiotis being there, appellant being there in the first place, was to purchase the property, and he could not do that. So no rent payments went to the purchase price, and the non-refundable deposits did not lower the purchase price as they were received, which is a required element for contract for deed under both Kellogg and Prue. While the non-refundable deposits would have been applied to the purchase price at closing, not before, closing never occurred. Appellees never agreed to finance the sale and did not transfer the property to appellant prior to closing. Only in 2018, 8 years after he entered into the lease, did appellant first bring up the idea that all prior rent payments should have been applied to the purchase price. That means he knew the rent payments were not being applied to the purchase price over the course of time, the entire time. Appellant could have negotiated a rent-to-own agreement, but he didn't. Appellant could have negotiated that any deposits were immediately applied to the purchase price, but he didn't. Under these facts, there is no contract for deed. Now, even if this court determines that it was oversight for the trial court to not specifically address appellant's unjust enrichment claim, that oversight is harmless error because appellant is not entitled to unjust enrichment as a matter of law. Appellant did not bring a claim for breach of contract. He brought equitable claims of retaliatory eviction, betterment, and unjust enrichment. Under Kellogg, while this court reviews the trial court's legal conclusions de novo, the trial court's decision to withhold equitable remedies is given deference, as is the trial court's findings of fact if supported by the evidence, which it is. The trial court denied appellant's equitable claims of retaliatory eviction and betterment and must be given deference for withholding appellant's equitable claim. To the extent there was error, it is harmless error. For the foregoing reasons, this court should deny the appellant's appeal